We've been joined by the Commissioner of the Commission on Human Rights and Administrative Justice, and we're talking about conflict of interest and corruption. We want to understand under which circumstances can conflict of interest be said to be leading to corruption, as well as having a better understanding of corruption and conflict of interest. My guest is the Commissioner himself, Joseph Whittal. Thank you very much for joining us.
Thank you.
Great. So tell us, what's conflict of interest?
Well, conflict of interest as defined in the Constitution is whenever a public officer puts himself in a situation where his personal interest conflicts or is likely to conflict with the discharge of his official functions.
What are those particular situations that you expect to guide, public officials when it comes to conflict of interest?
Actually, we've identified financial interests of public officials. We've identified situations of self-dealing when they have to deal with themselves in terms of their private businesses, and their public duties. We have also a recurrent situation which can lead to conflict is that of employment situation, recruitment, and official time use and abuse of office. Those are interests, say, in a family relation, your spouse, your daughter, your old boy from the university or the secondary school that you have met. You want that person to work with you. There's a tendency to allow your personal interest in that person to override the procedure that are laid down to ensure that the person who gets picked is picked on the basis of meritocracy.
If the president makes an appointment, or if the minister makes an appointment, for instance, and in that appointment he appoints the brother or sister, or say the classmate, how do you find out whether that person is qualified or not, so you'll be able to tell us, for instance, there's conflict of interest?
Now let's distinguish between presidential or executive appointments. The president has power to appoint certain people whom he will come with and whom he will go back when his time of office is over, he will live with. Those appointments are at his discretion.
So the president cannot be said to have engaged in conflict of interest if he appoints his son?
Well, but since you are the leader of the public service, you would want to send the right signal. If your son is qualified, no problem. But if he's not qualified and you have picked him because the rules allow you to pick people that you come with, to work with, and to leave, then the public will start to talk.
You have a challenge with what we practice now?
Not only me, but I think most Ghanaians have.
You have a challenge with it?
That we should begin to pick people on the basis of criteria that is merit-based. And so I also do.
The last time I spoke with you, you talked about how the laws have made CHRAJ technically ineffective in certain situations because there are issues you would like to investigate, but the law doesn't permit you to investigate those issues.
If there's no complaint, we cannot investigate.
Exactly, when it comes to issues of conflict of interest.
Yeah.
Is this one of the cases that the law prevents you from investigating, which you would have loved to investigate, for instance?
The law did not prevent us from our understanding of what the law was until somewhere in 2006, when the Supreme Court pronounced in the Anani case that allegations that are to be made to the commissioner in respect of conflict of interest should be seen as complaints and not allegations that will be treated as being in the media and the commissioner happens to read and decides to take them up. That is where the whole issue of our mandate to investigate without a complaint allegations of conflict of interest came to a screeching halt. Yeah.
Yes, but for that Supreme Court ruling, which is currently preventing you, would you have, investigated this issue, for instance?
Straight away.
You'd have investigated it?
Straight away. And indeed, the Constitutional Review Commission has actually indicated that that barrier that has been placed on CHRAJ should be removed in the next amendment of the Constitution. And we are all for it.
So when you read the newspapers, just finally on this bit, when you read the newspapers and you see some of these issues, you listen to the radio, you watch the television, and you see some of these things, are you sometimes saddened that you'd have to wait for a complaint before you investigate them?
Especially, I agree with you, especially when you look at our sister commissions in other countries, where they can investigate without a complaint on their own. You ask yourself, why would you set up a commission with such broad mandate and you qualify it, especially when it comes to the fight against corruption, and conflict of interest is a species of corruption? Why would you want to put a filter like unless you have a complaint? I'm looking forward to the next amendment of the Constitution to make sure that that filter is removed.
And if it's not?
Well, we are going to make sure that, and I hope NGOs and other civil society organizations and other public-spirited persons are all interested in making sure that the Commission should be given the latitude to investigate. Why, some of those cases that you have mentioned, people don't want to come out because they would be stigmatized. You are the one who brought this complaint. You are the cause of my problem. So for public interest cases, it is best that you don't require a physical, identifiable individual to come forward. You allow the institution to use its own discretion and go at it.
Okay.
That is how it happens in other countries.
Let me get your thoughts on another issue. I mean, so there we have it here. There are lots of the people who think that many of the contracts we have in this country are inflated. Does that amount to the abuse of trust in you?
Clearly, that is abuse of discretionary power. Why would you allow, if you are actually talking about competitiveness in the procurement process? Competitiveness is supposed to drive down prices. If you had actually allowed the principle of competitiveness to take place, there is no way inflation of prices would occur. Inflation of prices would occur if you either restrict, you sole source, or you handpick. Because at that time, you are not having the breadth and latitude of prices from other suppliers or to compare and be able to determine that this is a better price.
But under what circumstances can conflict of interest lead to corruption?
Well, if you allow yourself your personal interest in a given matter, patently you know that you have a personal interest, you have gone through all the assessment and evaluations, which indeed our conflict of interest guidelines have got some checklist that you can go through to find out whether this is a situation of a personal conflict, conflicting with your public official duty. If you go through that and you know that there is a potential of conflict of interest and you proceed to then still act, then of course you have crossed the realm of conflict of interest into active, palpable corruption.
Do you think if we make asset declaration public, it would go a long way in fighting conflict of interest and corruption?
For me, this booklet, which is actually the Code of Conduct and Guidelines on Conflict of Interest, which we as a commission developed to guide public officials in the management and identification of conflict of interest, we have since been able to convince government to put it into a bill. This bill sets out how guidelines on conflict of interest will now become provisions of a law with sanctions, including assets declaration, how they can be verified, how they should be published, either in the Gazette or in any other form. Because that is how you and I will get to know the assets of public officials, to be able to make meaningful complaints. If I don't know your assets and they are hidden in the Auditor General's office, how would I make a meaningful complaint about whether you are in conflict of interest or whether you are contravening the Constitution by not properly declaring your assets? It's only when they are there. And to be frank with you, this is not news. For Ghana, we have retrogressed. In the PNDC era, I happen to know, because at that time, I was a public official.
Oh, okay.
We declared assets, published in the Gazette. So why can't we? You remember the joke about Kwesi Botwe?
Yeah.
He is supposed to have declared a gramophone.
Yes.
Yes. It is because it was in the Gazette. Why can't we do that? The excuses that our members of parliament and other people are telling us that if you publish assets, you will bring armed robbers and thieves to your house.
Do you get the impression that MPs are comfortable with declaring assets publicly?
Oh, they made it very clear it's in Hansard. They said it will lead to armed robbery. It would create problems for inheritance for them. Some of them felt that, they inherit matrilineally and it is not proper for their assets to be known. I mean, please, we're in, is it 21st century? I mean, I'm surprised that we're still using such criteria. If we're actually fighting corruption, if good governance is what we are fighting for, you cannot say if my properties are known, my properties which I should be bequeathing to my nephew by custom, it should not be known, otherwise I may be killed earlier. I mean, please, we must make progress.
That's a genuine fear, isn't it? People get to know your things, they would fast track your passing away.
So what? But we've put certain people in official position, and we are also interested in whether you are fast tracking the public assets into your private assets. So you have to weigh the situation. What prevents you from having a number of guards around your house, making sure that you are careful? And how many of us actually have the properties that we claim we are so afraid it will lead to our deaths?
But finally, on the corruption bit, I mean, since you're tasked with investigating corruption cases, you don't need a complaint to. Over the last 2 years, 1.5 years, are there corruption cases going on that CHRAJ is investigating?
Quite a number. We're investigating corruption cases under Act 456, which is the Commissions Act. We're investigating corruption cases under the Whistleblower Act. We're investigating conflict of interest cases which are tied with corruption, because the conduct has gone beyond conflict of interest, but we are doing the two together. And
there are allegations of corruption in the Kelny GVG case. Are you investigating it?
There's no complaint before CHRAJ.
You don't need a complaint when it comes to corruption?
In any case, the matter is before court, and when the matter is before court, we don't go there.
But before it went to court, you didn't start investigations?
What we do, we have a team in our office that looks at all allegations in the media on corruption, on conflict of interest. They start preparing the dossier for the commissioner's, attention. But when they even prepare the dossier and the matter is going to court, then we have to kill it.
So was there a dossier preparation in this case?
I don't want to be prejudging the issue. If it crashes out of parliament, of court, we can always take it up. And I can assure you that there is no corruption allegations that are going on in the media where our staff have not prepared, because there's a possibility of a preliminary investigation going on at any given time. So they have to prepare and let us know. Before the matter goes before court, even in the case, there are some cases that you, as you sit here, you may not know. We may be investigating some public officials preliminarily without informing them. It is only when we have basis for undertaking a formal investigation, then we request comments and we give documentation.
Finally on this, there's been talk of alleged corruption at Bust, for instance. People have complained about it. I mean, the sale of off-spec fuel and the sale of fuel which was even in the tanks of Tor. Do you have some preliminary investigation? Are you doing some preliminary investigations into this also?
We did a preliminary investigation based on a complaint that came to the commission. This was not only on our own. We started on our own. A complaint came with a stack of documentation. We're in the process when same matter went before court.
Is this a defamation suit that has gone to court?
You'll be surprised to know that the defamation suit is packaged around the same facts that we're supposed to investigate. So it's not the title of the case, but it is whether the fact situation in court requiring a determination is the same as what has been brought before CHRAJ.
Mr. Joseph Weta, your closing remarks.
Well, I think the fight against corruption is a worthwhile fight. Some of us are happy with the support that is given by the presidency, but we think that we can do more.
What support is being given by the presidency? Just
political will. Setting up of the office.
You think this government has a political will to fight corruption?
I think we are getting the right vibes. We are getting the right vibes from the presidency. We are getting the offices that otherwise we have been fighting for. The office of the special prosecutor is right on. But what we are not happy with is that 6 months into the existence of that office, we are not happy with how the office has been empowered to undertake its work.
Why aren't you happy? What's the problem?
We think we could have done better. As anti-corruption bodies, we're interested in knowing the new kid on the block, what is happening.
Is it happening? You think the office of the special prosecutor has not been empowered enough to perform its functions?
Well, financially, we are not seeing that.
So it's not been empowered to perform its functions?
We don't think they have a budget. We haven't seen serious personnel being employed. Martin Amidu is doing his own preliminary investigations. We don't think that is the way to go.
What is the way to go then finally?
The way to go is for, how much does that office require?
Tell me.
If you give Martin Amidu a good office that can take minimum 40 investigators and other people who can actually do the work with him, I know he will do the work. I know that man and his commitment is there. But for now, he's sitting there with about 2 or 3 staff. 6 months? No, that's not. He shouldn't go. That office shouldn't go the way ours and others like Yoko have gone through.
How have yours gone?
I mean, we're talking about financial empowerment.
You're not empowered financially.
If you compare anti-corruption bodies between Ghana and Nigeria, I mean, you think we're joking.
That means you're not serious in fighting corruption then?
No, we are not. We are ready.
Yeah, but if you are supposed to be funded by the state and the state is not funding you,
yes,
it means the state is not willing to fight corruption.
That is why we think we should tell the state to do the right thing.
So tell them to do the right thing.
I'm using your medium to tell them that, look, empower us. We've seen some improvement in CHRAJ. Building our head office is good. Giving us more personnel is good. We have had 20 staff support this year. That's good, to fill vacancies. But what about the Office of Special Prosecutor? If you compare us with the Economic and Financial Crimes Office Commission in Nigeria, 4,000 staff in that commission, 400 lawyers who are permanently in court, and they are using non-conviction based asset forfeiture as a basis. So you are seeing physical rewards. we are still on the conviction based. How long will it take for Martin to take a case to court, to prosecute, and to go through the whole process of appeals right up to the Supreme Court? Come on.
We need to get serious.
We need to get serious.
Joseph Whittal, thank you very, very much for joining us this morning. We're very grateful.
Thank you.